Court of Appeals of Tennessee is now in session.
Good afternoon to the attorneys. You're welcome to the Tennessee Court of Appeals. I'm Judge John McClarty. I'll be presiding. Your panel consists of Judge Frison and Judge Davis and myself. Okay. You will present your case as if you were in court, except you won't have to stand. You will present it seated as you are. First of all, have the time restraints been imposed, and have the appellant a reserved rebuttal time?
Yes, Your Honor, I reserve 2 minutes.
Okay. I see 3 lawyers. Will there be more than one lawyer presenting on in any particular side?
Not for the appellant, Your Honor.
And the appellee?
No, Your Honor.
Okay, good. Are there any preliminary matters, Mr. Clerk?
No, Your Honor.
And will you please call the first case?
Phi Air Medical, LLC versus Corizon, Inc.
For the appellant,
Chrisandria Turner and Erica Barnes.
right ahead.
May it please the court? The Airline Deregulation Act only preempts state laws that affect air carrier prices. A ruling under a state's common law adjustment enrichment jurisprudence only affects air carrier prices if the ruling awards a rate at below the market rate that the ADA is intended to protect. PHI's rates are commensurate with the market rate. Thus, before the Chancery Court, PHI asked for relief in the amount of its usual, customary, and reasonable charges.
Let me ask you a question, Counselor. At any time prior to this case developing, was there any type of agreement with the defendant as to the pricing, the fees?
There was not an agreement.
From the very beginning, there was not an agreement as to what would be paid for the services?
No, there was not. And if I may explain just a little bit how that works is PHI is an emergency provider that is on a list of emergency providers. When an inmate needed to be transferred from one hospital to another, the next air carrier on that was on the list would transport the patient. And so that's why that there was never an agreement as to the price, like there is not an agreement amongst many healthcare providers, air carriers with Corizon.
Okay. Now, how had you been compensated prior to this litigation for your services?
The compensation we are seeking goes back to 2013. The compensation was decided unilaterally at Corizon's choosing. The compensation has been inconsistent. Since there was no contract, we weren't exactly sure how Corizon was paying PHI. We found out through discovery summer before last that they were using some form of Medicare and Medicaid rates, but not consistently.
So this was at their insistence. Your company had nothing to do with the amount of compensation received for the services rendered?
We had no ability to require Corizon to pay even for the flat level costs of what we were experiencing because there was no contract, and that's what led to this litigation. We tried to contract between 2014, 2015, could not reach an agreement. 2016, we filed suit. Since we have filed suit, we have continued to transport Corizon inmates because that's required of PHI as an emergency provider, but we have not been compensated at all for for the inmates we've transported since we filed suit.
Now, did I see somewhere in the record where the company before your company got involved with this, that they had a contract with the defendants?
In the record, exists something similar to that. The first 3 years of the litigation, Corizon had insisted, and we also were under the same belief, that no contract existed between PHI and Corizon. Then somewhere after the first summary judgment ruling occurred, Corizon pulled out a contract that they said covered Indiana, which covers maybe 3 or 4 of the accounts that are at issue in this litigation. And despite the first 3 years of saying no contract existed, they then said, well, here's a contract that our predecessor, PHI's predecessor, and Corizon's predecessor had between them. But it was only for the state of Indiana, and we do not recognize that because it was not with PHI or Corizon.
Okay, you may proceed.
So guiding us here today are the Supreme Court decisions of Morales, Ginsburg, and Wolins. In Morales, the Supreme Court held that the ADA preempts 2 types of state laws: laws that specifically reference and are directed towards air carrier rates, routes, and prices, and laws of general applicability that, although they are not intended to impact air carriers, they have a forbidden significant effect on air carrier rates, routes, and prices. In Ginsburg, the court held that state common laws are laws, regulations, and provisions having the effect of law within the meaning of the ADA and would be preempted if they had a forbidden significant effect on carrier rates, routes, and prices. Those claims, though, under Morales would still have to go through the forbidden significant effect analysis. And finally, our third Supreme Court case addressing the ADA is Wolins. It holds that state laws affecting air carrier prices are not preempted by the ADA if they are the carrier's own self-imposed obligations. Wolins was misinterpreted by the Chancery Court to hold that contractual claims are the only exception to the ADA preemption. And to the contrary—
Ms. Turner, I'm sorry to interrupt you, but the defendant, Corizon, says that this issue of whether or not your client can recover under the ADA, under a theory of unjust enrichment, has been tested in multiple courts throughout the country, and that no court has allowed this type of claim to proceed under the ADA because of preemption. What do you say to that?
I say that the unjust enrichment claims and cases cited by Corizon do not control the issue before the court. This is a matter of first impression before the Tennessee Court of Appeals, and the cases that Corizon has cited fail to analyze whether unjust enrichment claims have the forbidden significant effect on rates that I just described in the Ginsburg and Morales cases. For instance, in Riva, the court failed to analyze the plaintiff's assertion that the ADA is not intended to be used as a defense by parties other than air carriers. Instead, the court merely stated that the assertion without case law was unhelpful. Worldwide Aircraft, the court dismissed the unjust enrichment claim because the plaintiff would not be left without a remedy, since it allowed the plaintiff to proceed on an implied, in fact, contract claim. In Medical Mutual of Ohio, the court dismissed the non-air carrier's claim of unjust enrichment, but allowed other claims to go forward. In Scarlett versus Air Methods, the court indicated that the ADA preempted courts from imposing an equitable remedy in absence of a contract and cited Wolins. Actually, Wolins did not say that, so the Scarlett court misquoted Wolins. Instead, what Wolins does hold is that the ADA contains no hint that a federal court should fashion a common law remedy. That is also what was said in Dan's City versus Pelkey, which is a case that supports PHI's position. I would ask the court to take a look at that one. So what Dan City said is, if all state law claims are preempted and there's no federal common law and there's no contract, there would be no remedy for the plaintiff, and no such design could be attributed to a rational Congress. In Byler, this is not an unjust enrichment case. This issue was whether the trial court properly dismissed the declaratory judgment claim, regarding which the appellate court took no position. It's an unpublished decision. The appellate court dismissed for preemption reasons plaintiff's implied in fact contract claim, and it sua sponte discussed the unjust enrichment claim, which was never pled by the plaintiffs and was never defended by the defendants, and neither party put forth evidence in support or opposition to the claim of unjust enrichment, and the issue was not litigated and it does not control. I'd like the court to go back to Morales, Ginsburg, and Wolins, because that's what drives this case. That's what guides us to help us determine that the unjust enrichment claim can go forward.
Is the unjust enrichment claim, is this the only basis that you have for recovery in this case?
We have also filed count 2, the action on account. The court used the same reasoning to strike and dismiss that count. Had the court gone through the analysis that is required under Morales, Ginsburg, and Wolins and gotten to whether the unjust enrichment claim ruling would have an effect on rates, routes, or prices, if it had done that analysis, it would not have dismissed that case either. Because under that
sworn account you're referring to?
Pardon me?
On the sworn account you're referring to?
Yes. So at the point where Corizon disputes PHI's position on the amount owed, PHI at that point would have had a right to put forward into the record usual, customary, and reasonable rates and evidence of that, which is what is regulated in a fair market. PHI never got that opportunity because that count was dismissed as well. So in this case, when we asked the Chancery Court to apply Tennessee's unjust enrichment common law claim to PHI's rates, it should have used the analysis under Morales and Ginsburg, because what we were seeking was a ruling on unjust enrichment. That is a law of general applicability. Therefore, there should have been a forbidden significant effect analysis to determine whether air carriers' rates, routes, or prices were preempted. Had the court properly applied Wolins, it would see that PHI is seeking enforcement of its own self-imposed rates, and therefore an award under unjust enrichment comports with the ADA Supreme Court jurisprudence. Support for PHI's position, I would like the court to look at Dan City Used Cars versus Pelkey, which I mentioned a few minutes ago, because it contains a clause that is materially identical to the ADA preemption clause, except it relates to motor carriers with respect to transportation, i.e. towing. Pelkey sued Dan City after Dan City sold Pelkey's car and applied the proceeds to Pelkey's towing fees. And so Dan City argued that Pelkey's claims should be preempted because they relate to towing. The Supreme Court stated if such state law claims are preempted, no law would govern resolution of non-contracted based disputes arising from a towing company's disposal of a vehicle previously towed or remedy for wrongful disposal. Federal law does not speak to these issues. Thus, not only would preemption, as urged by Dan City, leave vehicle owners without any recourse for damages, it would eliminate the sole legal authorization for a towing company's disposal of stored vehicles that go unclaimed. This cannot be attributed to a rational Congress. What I would like to point out—
This is one of the cases that you cited in your brief?
Yes. I would also like the court to look at Farrell versus EVAC, as well as Texas Mutual versus PHI that came out in June of 2020. But I want the court to remember that the private actor intended to be protected under the ADA is an air carrier, not a non-air carrier, and upholding the court's decision would lead to an absurd result.
Thank you. You have your rebuttal time.
Thank you.
And for the appellee?
Good afternoon, Your Honor. Edmund Sauer of the Nashville Bar on behalf of Corizon. I'd like to jump in and first talk about the state of the law on this unjust enrichment issue, Your Honor. Every federal and state court that has addressed this question nationwide has reached the same result as the Chancery Court. And that's because the plain and unambiguous language of the preemption provision in the ADA is controlling. Any state common law claim that relates to price that's non-contractual is preempted.
It's your position that that the plaintiff does not have a remedy for payment other than what you unilaterally paid them?
I'm not sure I understand your question. As I understand the plaintiff's claims here, they've been exclusively based on non-contractual implied in law claims, both the unjust enrichment claim and also the action on sworn account. As the Chancery Court found, both of those were based on implied obligations imposed under law and not contractual obligations that the parties readily could have entered into, but did not, as Ms. Turner acknowledged earlier.
Let me just kind of follow up on that. I think the question is, like you guys, there's no contract here, we know, and I'll exclude Indiana from this because I know there's an issue about that. But I mean, it seems to me you guys have just been paying PHI, I think, Medicare reimbursement rates, but really whatever you decide to pay them. What if you guys decided not to pay them anything? What remedy does Corizon have?
Yes, Your Honor. Let me clarify. We, in a number of states, don't have discretion in what we pay to medical providers. States like Arizona, we've entered into contracts with the state which require us to pay at certain statutory or regulatory rates. In other states, we have entered into contracts or there are administrative regulations that require payments at certain rates. There's no evidence here that we just pluck a number out of thin air and pay a grossly insignificant rate. To the contrary, I don't think there's any dispute that what we pay is a Medicare-based rate, generally speaking. And of course, that depends on what the state laws are and what our contractual obligations are. What
so you
PHI
guys you're either following a contract if you have it or statutory rates from that particular state.
Yes, Your Honor. We're a government contractor. We're doing business with the state. We're going to follow those laws, and that's what we do. Most of the services provided in this case were in Arizona, and there is a cost containment regulatory structure that we follow. We don't have any discretion to deviate from that. So the idea that we would just pay $1 and get away with it doesn't hold water here. We're complying with the regulatory structures that the states put in place, with the contractual obligations that we have with the contracting entities in providing reimbursement to PHI and paying them for their services. What's unreasonable are the unilaterally set prices that PHI is trying to recover in this case. 9 times Medicare rates on average is what they're seeking here. And that's exactly the type of equitable state law claim that the ADA preempts. In 1978, the federal government enacted the ADA to prevent this type of state regulation of what an equitable or reasonable fee would be for air carrier services. And that's why every court that has addressed this has rejected this claim, because you don't want to have a patchwork of varying state laws from state to state trying to figure out what a reasonable or equitable rate is for air carrier services. That is a matter of federal law. And if PHI is concerned that the Medicare rate is too low, their remedy is with CMS and Congress and the federal government, not with state courts, particularly courts of equity, to try to engage in a very fact-intensive varying analysis of what a fair price for air carrier services is. So on the law, every court that has addressed an unjust enrichment claim like these, that have applied Morales and Ginsburg and Wolins, has reached the same result here. And there's no basis to create a conflict in this case, Your Honors, and reach a different result.
Did they know the amount of the fee before the services were rendered?
Yes, Your Honor. Those are published in regulations and statutory frameworks. They know going in what the rates are going to be.
But your company did not have an agreement with them as to what this fee was going to be, though. Is that correct?
We did not, and it's undisputed that in 3 of the 4 states here, there was no contractual agreement. Indiana is the only state where there may have been a contract at issue, but to succeed on their equitable claims, Your Honor, they have consistently stated as a matter of fact, there is no agreement. And so we operate for purposes of the preemption argument here that there is no agreement. These are equitable claims based not on the party's voluntary agreement, which PHI has entered into with other insurers and with us in the past. We didn't reach a deal on this. And so now what they've tried to do is do exactly what the ADA says you can't do, is try to impose equitable, reasonable prices under state law in an equitable claim for unjust enrichment. So we have a deep body of case law that we've collected in our brief that addresses 2 types of unjust enrichment claims. Claims by consumers like Corizon, who end up with a bill for $30,000 or $40,000 for a helicopter ride, and they bring a suit in federal or state court under unjust enrichment theories. And in every single case, the air carrier says, well, wait a second, these claims, these unjust enrichment claims are preempted because they relate to air carrier prices. And they have won every single case. There's also a body of law where it's flipped, where the plaintiff, as in this case, is the air carrier. And they're claiming that a customer like Corizon has underpaid for their services. And again, every single court that has addressed the question has found it preempted as a matter of law because those types of claims fall within the broad protective preemptive sweep of the ADA. Now, Ms. Turner's, it sounds like her lone argument to deviate from this body of law is what she claims is a requirement for preemption, that there be a forbidden significant effect that the trial court didn't do here, a significant effect on prices. That is not an open question in Tennessee. The Tennessee Supreme Court in Knock resolved the governing standard. This court addressed it in the Muson case thereafter and made very clear that there was no significant effect requirement if the claim on its face relates to air carrier prices. In Knock, the standard that the court adopted, and I quote, the claim must be related to airline prices either by expressly referring to them or having a significant effect on them. So the standard is disjunctive. If we show, and I can't imagine there being a dispute that these claims on their face are related to price, it falls within the ADA preemption clause. The or indicates that there's another way to establish ADA preemption. And this is the case, as Ms. Turner pointed out, some of these cases involved laws of general applicability. The same standard applies. In Muson, it was a negligence claim. In Knock, it was a negligence claim. And the Tennessee Supreme Court's adoption of the standard is, of course, consistent with Morales and the 2 cases that followed Morales, Ginsburg and Wolins, which just looked to see whether the claims on their face related to price. The court engaged in no quantitative analysis to see if there was a measurable effect on prices. And that's because it's not required. And it's certainly not an open question for this court to reconsider in this case. The facial relation to price is enough, as the Chancery Court recognized, to trigger ADA preemption. The other issue that was brought up was the notion that applying ADA preemption here would deprive PHI of a remedy. And that's misleading. The way consumers protect themselves in this context in a deregulated environment is through contract. That was the whole purpose of the Airline Deregulation Act, was to get states out of the business of regulating the prices. And if any regulation is to come, it's to come from the federal government. And so again, we're not randomly picking grossly insufficient prices and paying them inconsistently. There's no proof of that. If they wanted a contractually enforceable agreement, they could have entered into it with us. Once again, what they've tried to do is walk away from the bargaining table and use equitable principles to enforce on a government contractor prices to which we would never agree and that we legally could not agree because we're bound by our contracts with the states and the localities and also by those laws. The second point I would make relating to that is even if they were without a remedy, it's not a defense to preemption to say as an equitable matter, the plaintiff has suffered a harsh result, and so we should deviate from the preemption clause. In those cases where I talked about where the consumer was left with a $30,000, $40,000, $50,000 bill from the air ambulance companies, every single court that addressed it said, you know, this is really harsh. This is harsh that there's no state law that's able to keep these prices in check for the consumer. But harsh results don't allow a court or state law to deviate from the plain and unambiguous language of the preemption provision. And so the courts applied preemption in that context and have consistently applied it even when there is not a state law remedy in this context, where the air carrier is seeking to recover purportedly equitable prices above and beyond what Medicare provides. My friend refers to the Dan City case. And I want to say just a couple of things about that. The preemption provision at Dan City is very different than the preemption provision we have here. In Dan City, the court said very clearly that there was language in the preemption provision there that massively limits, and that's the court's terminology, massively limits the scope of preemption there that doesn't apply here in the ADA. And what the court noted in dicta at the end of its opinion, it said, okay, the plain language of the FAAA preemption provision, which is what was at issue there, the plain language indicates that these claims aren't preempted. But then it said again, you know, it wouldn't make sense to apply preemption here because the plaintiff wouldn't have a legal remedy to right an illegal action by the defendant. And so we clearly are not engaged in illegal conduct. We're paying rates consistent with what state law requires us, what our contracts with the various states require us to do. And so Dan City really doesn't help this analysis. The Supreme Court's opinion in Ginsburg does, which refuted the idea that the unavailability of relief somehow would limit the scope of preemption under the ADA. And again, every court that has addressed this question have rejected not only the legal standard argument that Ms. Turner is making that's inconsistent with Tennessee case law on point, but also the policy and equitable arguments. Sometimes harsh results occur in a deregulated marketplace. This is not one of them because we have paid a market rate for air travel for incarcerated inmates that are set by the states and the local governments. But even if that were the case, it's Congress's prerogative, not state courts, to fix whatever problem that might exist. And my last point, I'll leave the court with this. Congress is poised to act in this area of the law. Congress created an advisory committee to look at these issues of air ambulance, prices, Medicare reimbursement rates, and preemption. And the advisory committee has been meeting and discussing and recommending legislation to Congress. So there is a venue for these arguments, and Congress may one day change the language of the preemption provision. But as every court that has addressed this question has held, as currently worded, unjust enrichment claims that seek to impose reasonable prices, not based on the parties' agreement, but on equitable claims, are preempted as a matter of law. And so we'd ask the court to affirm the Chancery Court's judgment.
Thank you, sir. For your rebuttal.
Yes, there's a few things I would like to point out to the court that's in the record, Mr. Sauer has only been in the case for the last 4 months. He may not know these. Don't let Corizon fool you. They are the largest government, not a government actor, but the largest for-profit correctional care provider in the country. They have been paying Medicaid rates well below Medicare. Medicaid rates are $3,000. That's it. That's not even enough to get the bird off the ground to carry the inmate. Even the base.
Let me ask you this. The states that we're talking about, if I'm correct, are Arizona, Indiana, New Mexico, and Maryland. In Indiana, there may be a contract, but Arizona, New Mexico, and Maryland, is it correct to say that there's no contract for those states, but rather you guys have you've invoiced Corizon for what you feel is the appropriate amount, and they have paid you and reimbursed you based on Medicare rates? But is that not according to those state statutes?
It is not. The state statutes that they refer to are the type that facially do not apply to air carriers. What Corizon is paying is some form that's not even enough to get the bird off of the ground, like I say. And I do recall Mr. Sauer saying that under the Knopp case, the or having a significant effect, that's the rest of the Morales case. That is exactly what we're saying, the or forbidden significant effect that the Chancery Court didn't do. All that we would like to do is to go back to the Chancery Court and put into the record evidence of our usual, customary, and reasonable rates for the court to see so that we can be paid accordingly.
Thank you very much. I want to thank the lawyers for your presentation. This is, without me saying it, obviously a very interesting case. Your case now has been submitted to the Court of Appeals, and we will render our opinion and our judgment within a due course of time. Again, I want to thank you for your presentation. The lawyers may be excused.
Thank you, Your Honors.
The Honorable Court is now in recess until 3 p.m.